Hello everyone and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we'll share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just a note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to our speakers to get us started.
Good morning, good afternoon, and those in arbitration hearing somewhere right now, good luck. Welcome to this Lexology Masterclass on navigating arbitration in energy concession agreements, pitfalls, protections, and precedents in partnership with Mason. My name is Vivek Malviya, and I work as Director Claims and Contracts and as a forensic delay expert at Mason, and I'll be your moderator today. We are diving into a topic that sits right at the intersection of energy infrastructure, public-private collaboration, and global risk. The humble but high stakes energy concession agreement. Whether you are negotiating a solar farm in sub-Saharan Africa, a pipeline in Latin America, or LNG terminals in Asia, these agreements are long-term, politically exposed, and financially intricate. Arbitration is increasingly the preferred safeguard against breakdown in these deals. But that doesn't mean it's easy. Today, we are exploring common pitfalls in drafting arbitration clauses in energy concessions, the legal and structural protections that can make arbitration enforceable and effective, and finally, we'll draw real world lessons from landmark energy arbitrations. To guide us through these thorny and fascinating issues, we have with us a panel of top tier specialists who have seen these disputes play out from the negotiation table to the arbitration hearing room, and sometimes even beyond. Our first panelist, Lucy, is a leading KC specializing in construction, engineering, energy, and shipbuilding, with a particular focus on projects involving complex factual, technical, and contractual disputes. Next up, James Holden, a partner at Dispute Resolution Group in the London office of White and Case, whose work spans some of the most dynamic and politically sensitive jurisdictions, including East and Southern Africa and the Middle East and Southeast Asia. And finally, we have John Murray, Managing Director at Econ One Research and a globally respected expert on damages, valuation, and quantum analysis. With that, let's dive into today's discussion, structured around 5 key themes and ending with a lightning round of takeaways. We'll keep it tight, insightful, and wherever possible, slightly entertaining. Let's start by pulling back the curtain. Energy concession disputes don't just arise from bad behavior. They are often baked into the nature of the beast, long-term contracts, state parties, and shifting politics. I'll start with James. So James, you have worked across extensively across jurisdictions like East Africa. So what makes energy concession agreements, especially in emerging markets, uniquely prone to disputes? And what makes arbitration a preferred route in these high-stakes scenarios? James.
Thanks, Vivek. Well, I mean, as you were saying in your introduction, these kinds of agreements tend to be quite politically exposed and long-term in nature. So government intervention is often a driver of disputes in this area. And, it's just a fact of life that intervention by governments tends to be more prevalent in emerging markets, particularly, I think, upon a change of government. There's still a lot of, a feeling in a lot of emerging markets that, those deals were the previous governments, we're going to make our own deals and we're going to get rid of those ones. So you still get a lot of that happening. And that can really drive disputes. And given that you know, as you said, a lot of these are kind of long-term agreements. They're more likely to be impacted by government change. There's more likely to be changes in government during the course of the agreement. And there's a need to try and kind of ride those roller coasters and try and keep in with the new government when they come in as well, which can be difficult. There's also, I think, a tendency in these types of contracts for them to include unrealistic financial assumptions at the outset, again, particularly in emerging markets where perhaps there isn't, you know, a great understanding of the market and how it will develop over the years. And that can lead to disputes, attempts to renegotiate, again, particularly where we're talking about multi-year, sometimes multi-decade agreements that, you know, will need to be relooked at, rethought through, renegotiated as things change. And if you've got unworkable or unrealistic financial assumptions baked in at the outset, then that can make those negotiations more difficult and can make kind of parties get kind of bogged down and dug in their positions. In terms of what makes arbitration a preferred route for these kind of disputes, I think it's a popular choice for the kind of same reasons that it is for other types of dispute. But in particular, I think confidentiality is key. Obviously, some of these arbitration agreements will be ICSID, where there is perhaps less confidentiality than, say, an ICC agreement. But even then, the confidentiality is still greater than in national courts. And in particular, I think, you know, you don't have reporters in many of these countries following the ICSID lists as they would the kind of the local court lists. So you do get more confidentiality. You also see a lot of these that even where you've got a state and an investor, they are ICC, maybe LCIA arbitration agreements where, you know, there is more confidentiality. And I think the other key thing that you obviously get in arbitration is those specialist decision makers. Again, because these are such long-term agreements, they have often very complex pricing, risk-sharing mechanisms. It does help to have people who understand them making the decision, and obviously being able to choose your tribunal is a real boon in making sure that you do get people who are high quality and who have, you know, real experience in this sector and understand how some of these very esoteric clauses that we see that are kind of natural in these agreements, but not in your kind of standard commercial agreements. They understand how they work, how the industry kind of sees them and treats them. So I think those are really the kind of key things that drive the popularity of arbitration for these disputes.
So it's part political, part economic, and part contractual. Quite an unstable cocktail for sure. Moving to John. John, let's talk numbers. How does the structure of these agreements, long-term duration, state parties, and regulatory predictability affect the way damages are modeled or valued in arbitration? John, we can't hear you.
Thank you, Vivek. The scenario that James shared with us is one that we face frequently, whether it's a change of government in emerging markets, whether it's a retroactive policy change, as in the case of Spain and renewable energies. Mostly, and I'm sure counsel would agree, the consequences or the impacts are not clear enough for the policymakers and the decision makers when effecting those changes. Often they are ideologically based or short-term political goals because of the tenure of the change of government or even the policy. For us, when quantifying these impacts, economic, financial, and increasingly socioeconomic impacts. The ability to work, the ability to get to work safely and securely and efficiently. So the longer these contracts, the greater the risk. It's a rule of thumb. Of course, it impacts the discount rate that we use to bring back these future cash flows or these future scenarios and their results to a present value on which decisions are made. Remember that often when these impacts are estimated, the decision is made on the net present value of these projected cash flows. So, or comparable transactions or a cost recovery, etc. scenario. But at the end of the day, it's that discount rate that takes all these risk premiums into account. Now, I'm not going to get into all the weeds, but at the end of the day, these political decisions have major impacts, not only in the uncertainty of what we would estimate based on real experience. For example, our team are not just consultants and experts in financial forensics or indeed in quantum, but we've all worked in industry, whether it be in East Africa or in the Middle East or even in Russia and the subcontinent. It's about understanding the real challenges to businesses that are then projected as these estimates. What helps us a lot is working within a framework that is protected by a bilateral investment treaty, or otherwise known as a BIT. These provide us with guidelines. They provide us with precedents of other cases within the confines of a BIT. And of course, we find them increasingly in ICSID, where those investment disputes are typically held, sometimes mainly in Washington, but elsewhere as well. And then in terms of our approaches, the IVSC, the International Valuation Standards Council, suggests three main ones, which is the discounted cash flow. We project the economic performance of an entity or a consortium, and then generate cash flows that we then discount back at a risk-adjusted rate or discount rate. We also look at comparable transactions. What has happened in those markets? What transactions have occurred, and what was the result of that valuation, if you wish? Or it's based on what you've invested. What are the sunk costs? What are the cost replacement options? Again, all on a net present value so that we can adjust for risk. So I think in summary, what we look for is to project a realistic set of numbers that are then adjusted for operational, financial, political, climate, and other risks. I think that in the end is really where the rubber hits the road.
Right, right. So now, since that we have set the stage, let's head to the drafting table. Lucy, let's talk about multi-tier dispute clauses. How dangerous can vague or multi-layered clauses be in live disputes? And how you think can parties strike a balance between flexibility and clarity when structuring multi-tier dispute resolution clauses? Lucy, you're on mute.
How very 2020 of me.
Yeah.
Thank you very much, Vivek. So badly drafted clauses are obviously pretty dangerous for the parties. Good news for the lawyers, and that's never going to be anybody's aim. I think one of the first things to remember about multi-tiered dispute resolution clauses, which are obviously very, very, very common in this type of agreement, is that if you're up against a limitation problem, you can just start your arbitration without complying with the clauses, and often people are very worried about having to go through all the steps before they issue the notice of arbitration, because the clauses are often expressed to be condition precedents to the ability to start the arbitration. But there is certainly in English law useful case called Sierra Leone Mining, which establishes correctly, in my view, that they don't stop you from issuing the notice of arbitration. And what the arbitral tribunal will then do is look at the clauses, and usually if they're enforceable and clear enough, give effect to them after the start of the arbitration. So you won't lose the benefit of the negotiation period and the staged discussions that those kind of clauses usually envisage. It will just happen after the start of the arbitration as opposed to before it. That will obviously mean that you can't circumvent them by issuing a notice of arbitration. So you can't get out of going through the stages. So there may be some delay to the substantive start of the formal proceedings, but obviously the tribunal is going to be concerned to give effect to what the parties have agreed they will do before they get really stuck into the arbitration. So quite often what tribunals do is just stay the arbitration to let the parties get on with their dispute resolution process without incurring loads of costs. If the clauses are vague, they may be unenforceable, or, and probably more saliently really, cause unedifying peripheral disputes about what the meaning of the dispute resolution clauses are. So the parties end up spending money arguing about what they're supposed to be doing before they're even starting the real dispute. So that is a good reason to try and have a look at the clauses that are obviously at the back end of an agreement that nobody wants to talk about when you're doing the deal, to try and work out whether there's any implicities in the drafting. And I think on a practical level, if the clauses are too onerous, i.e. they require too many stages, which or involve stages which are effectively compulsory mini litigation of the dispute, that can also be a waste of time and money. And it's very difficult once you're in a dispute with a party to agree with the other side that you'll miss out a stage, because usually someone's got a vested interest in insisting that everybody does what they're supposed to do, even if the vested interest just kick the can down the road as long as possible and deter the claimant side, usually by making them spend money on the sort of interim stages. So in my opinion, I mean, I'm obviously a disputes lawyer and I don't do the drafting of the contracts, and I'm very aware that the deal that gets done is the deal that can be done at the time, and it's not always the case that you can have a perfectly clear or perfectly desirable set of clauses, because there's live interests at the time of doing the deal. You're not working in a vacuum. There's obviously commercial pressures, and people want, sometimes a vague clause is the clause that can be agreed. So that said, what you're aiming for, I think, is some kind of mandatory higher level discussion that takes the dispute out of the project team, who may have got quite cross in the lead up to the dispute, and hopefully gives it sort of fresh eyes, without making everybody spend months and months going through a process of a sort of mini litigation before they get onto the actual tribunal hearing.
Right. So these clauses can be great for lawyers, but not so good for project timelines, I understand.
Disputes are great for lawyers, Vivek. We love it all.
Definitely, definitely. Moving to James. James, you have seen your share of these contracts go from negotiation room to hearing room. In your experience, what are the most frequent but avoidable errors parties make in drafting energy concession agreements?
Yeah, I mean, just picking up on where Lucy ended, I mean, obviously the deal that can be done is something that is a problem throughout, not just in the dispute resolution clause, and it often leads to complex terms that, you know, as Lucy said, are perhaps a bit vague, don't necessarily make too much sense. But it was that fact that they were open to interpretation, which is what made the two parties be able to agree on them, because both sides could put their own views upon the clause. Obviously, that then becomes a problem when what you need one view and only one view to prevail. So that can often lead to problems where there have been those commercial compromises to get the deal done that don't perhaps give you the best drafting possible. And my sister-in-law is a front-end lawyer, and I often complain to her about terrible drafting and open clauses, and she says she's always pushing back, say, well, that was the deal that we could do. So there you go. Obviously, there is that tension between disputes lawyers who, well, perhaps we would like things to be clearer, but then maybe we'd have less arguments, as Lucy said. So maybe we shouldn't complain too much about our front end brethren. But beyond that, I think, you know, there's a few things that tend to create problems. I mean, it tends to be around the money. As we were saying earlier, and in particular, as Jean-Marie was picking up, you know, it's always the money that leads to the problems. So, you know, unrealistic financial assumptions, mechanisms for price adjustments that just are overly complex or just completely unworkable, and how you make that work in practice. I mean, the number of disputes that I've seen that purely revolve around the pricing mechanism and how that should actually work is phenomenal. And I do sometimes think that surely people should be learning from these issues and trying to make it simpler, but that never seems to quite be how things work. I think also, you know, as Jean-Marie was saying, these are long-term agreements. The longer they run, the greater the risks are. And the other thing that comes out a lot in these disputes is that there was a failure by either one party or both of the parties to understand the risks and how they were going to be allocated between the two parties. And obviously that then has an impact upon the financial assumptions you've made. So we see that a lot at the construction phase in particular, but also you see that around, I think, insufficient flexibility being built into contracts to deal with changes in policy direction. And that's, you know, almost certain to happen over the duration of these very long-term agreements. So I think those areas are really the kind of drafting holes that we often see that are creating these problems.
So there are unrealistic assumptions, risk dumping, and complex formula. So it's more like a fiction writing more than a contract drafting sometimes. Yeah. So let's switch gears from problems to solutions. What does a well-structured arbitration-ready energy concession looks like? Uh, so John, starting from you, from a quantum perspective, what pre-agreed contract mechanisms, for example, indexation, performance metrics, can help reduce valuation uncertainty during arbitration? John, you're on mute again. John, you're on mute.
Too many mute buttons around. Good morning. Thank you, Vivek. James hit the nail on the head. It's about flexibility, and you know, having come from industry, you sit down, you negotiate with the help of counsel, with the help of lawyers, but at the end of the day, the agreement has to be workable, not just a fine piece of legal prose. And we found that quite often, particularly when we negotiate in a public-private partnership, which is often the case in infrastructure, where one of the parties is government or a government department, and is probably not as experienced in practice, in business practices as they should be, you find price mechanisms that are unrealistic, to James's point. You find that there are clauses in the operating contracts that are confusing, let alone confusing to one of the parties, but sometimes to both parties, because the interpretations are 180 degrees apart. So what we try and do, the first thing we tend to do is to put a risk matrix out. And we have advised some governments prior to setting up a public-private partnership agreement where you do the value for money exercise, which is a tremendous piece of work. But that investment, I hope, to Lucy and to James's points, helps to avoid these ambiguities and this confusion and to make contracts more workable. The value for money exercise is a significant piece of work, but for good reason. So once we've established our risk matrix that identifies the kinds of risks, the ranges, and some of the mitigation measures that are available, one of the major ones is to look for independent funders. So you'd have third-party funders through the auspices of the World Bank or the IFC through a bond issue. We've recently had cases. They will require independent benchmarks, independent studies, independent analyses, what they call impact assessment studies. Typically, these are economic, they're financial, they can be environmental, and they are now socioeconomic, where independent benchmarks are now established as guidelines for future performance and measurement. And we found that things like price indexation, which, as James points out, in our experience has sometimes been most unrealistic, particularly in a developing economy, which is prone primarily to exchange rate risk. You know, you have a clause that is in US dollars. Well, there's absolutely no way when your inflation is running at double and sometimes triple digits, but still it's in the contract. And we then sit down and say, look, here is a possible mechanism for you. The operating benchmarks, we found in some contracts that these operating benchmarks come out of studies from the World Bank, rather than reflecting the reality of the country in which the contract is going to be operational. And these are real experiences. This is not Shakespeare. And then the equalization mechanisms. And I think both Lucy and James will have deep knowledge of the Spanish government's retroactive legislative changes on renewable energy, where the equalization mechanisms were absent, largely absent. And one of the parties in the dispute was an operator in California who was impacted in terms of his delivery in California because of the regulatory changes that had occurred retroactively in Spain. So their budget didn't stack up and they couldn't deliver even at a break-even level. So that generated the dispute. And I think these equalization mechanisms, I think, are intended to be practical, but quite often in our experience, they are not, because they are not based on the reality of the country or the sector or that reflect the challenges of that particular project. And then at the end of the day, it's better to do a robust risk analysis, the risk matrices, look at some of the studies that have been concluded independently by multinational institutions like the World Bank, the IDB, some of the regional development banks, that guide what these metrics could be, what these benchmarks could be, and more importantly, where they have failed in the past and what we can learn from so that not to repeat them in the future. And I think, at the end of the day, I come back, it's common sense, and go back to what's worked and what we can fix to make it better for the next time. And we do that in our evaluations.
Right. Now, Lucy, let's talk about fast track tools like emergency arbitration. What's your take on incorporating emergency arbitration or expedited procedures in these clauses? Do you think they are practical or they can go problematic in large energy projects?
I think adjudication is coming for us all. And the reason for that is that it works. And we can see the sort of spread of adjudication. I won't say it's like a rash across the world, but across the world and across the standard form contracts as well. And obviously contracts like NEC are being used more in energy construction cases, and some of the offshore forms are starting to incorporate a version of adjudication. And I think the reason that adjudication is more successful than DRBs are, and obviously DRBs have been a feature of energy contracts for many, many, many years. I think it's because the adjudications are optional rather than mandatory. So the parties adjudicate when it's actually useful to them to adjudicate, and if you keep to the sort of true spirit of adjudication, it's also genuinely short. So it's not a process that goes on for months and months at a time, which a DRB can be. And the number one thing that makes adjudication functional and better is that it's temporarily binding. And that means you actually get a decision that both parties have to abide by pending an arbitration, or obviously in the UK in litigation. And that really does mean that you can stop fighting about whatever it was, get on with the project, and everyone knows where they are. It's not just a dragging on defect. But I think that's that you can, whether you call it adjudication or whether you call it emergency arbitration or expedited arbitral procedure, those are the three characteristics which in my experience make it a useful procedure for the parties, and not just another step that they have to go through where everybody wastes time, and it's almost like everyone's in a kind of holding pattern, and everyone's going to ultimately end up in arbitration. The other, from a practical perspective, if you're going to do any form of expedited procedure or DRB or anything like that, what you want is a sensible tribunal. It's as important as the makeup of your ultimate tribunal for the arbitration. And the wild card in adjudication in the UK is who is your adjudicator going to be? And nominating bodies don't solve that problem. So in the UK, very often you have people agree on who the nominating body will be if they can't agree on the identity of an adjudicator. But unfortunately, all the nominating bodies people use have some less desirable persons who might be appointed. James is laughing at me because I'm trying to be discreet.
I seem to get all of them as well, Lucy.
Yeah, no, quite. I feel the same way sometimes, apart from my existing adjudicators, if you're listening. So you've got to have somebody sensible, otherwise the whole thing can get completely derailed, or you get just a sort of hopeless decision which you have to, nobody can live with. So that's hard to achieve in practice, but that's a really the sensible thing to do for both parties is to agree somebody at the point the dispute arises, so that both sides know they've got someone sensible, and then you can predict the outcomes. But I think what Jean-Marie was saying about the pre-agreements that can help was very interesting. And I was just going to add that we were chatting about this before we started the panel. I took a sabbatical from being a barrister a few years ago, and I went to live and work in Sierra Leone, working with government. And one of the things I did was I was asked to help the Ministry of Energy in Sierra Leone negotiate construction contracts for new power generating plants that were under discussion. And the currency risk was obviously a very difficult one to negotiate. But one of the hallmarks of the whole process was that in developing countries, sometimes on one side of the table, people are not necessarily aware of where they should be targeting their efforts on the negotiation. They don't realize necessarily that the currency risk is going to come back to bite them. And the point about using World Bank studies rather than real life, I totally agree, is a major problem. You say to some degree you have an inequality of arms problem at the negotiation stage sometimes. That's obviously a fact of life, but it doesn't having a contract that's wildly in your favor as a matter of the words that are written doesn't necessarily result in a successful outcome to the project. And so I think people can sometimes get a little bit bogged down in, I've got this great clause that's really going to shaft the other side, but that's not going to help the thing get built and everybody move on and do their business and not get into a big dispute about it. So there's a kind of short-term and long-term agenda that I think needs to be borne in mind.
Right. Now, talking about power plays in arbitration. Arbitration isn't just a dispute resolution tool, it's a leverage, it's a strategic pressure at times. James, moving to you, in a real world project negotiation, in what ways you think can investors use arbitration, not just as a resolution tool, but also as a deterrent or leverage during mid-project negotiations or disputes with authorities?
Yeah, I mean, as you said, Vivek, just the threat of arbitration can often be enough to kind of force parties to the negotiating table where perhaps they were previously reluctant to do so. And also the arbitration can be a good way of setting an opening position for those discussions. You don't tend to see people starting their arbitrations with a number that is the number that they're willing to settle for. They go in much higher and use that to leverage the actual position they want. And there was recent reporting on a dispute concerning a concession for the Brazilian power transmission lines, where negotiations had been ongoing. They hadn't gone anywhere, they'd stalled. The company that had the concession then brought an arbitration against the regulator, claimed substantially more in that arbitration than it was seeking in the negotiations. Actually then lost a preliminary issue relating to how those valuations would take place, which effectively took out their much higher claim that they were bringing in the arbitration, but then ended up getting a negotiated settlement, which was pretty much where they had apparently been at the outset. So I think that shows the power of bringing in arbitration. Even if you lose a point, it brings, it gets people, forces people to think about it. It forces people to the table. And actually by going in higher, you can sometimes kind of force people to kind of agree at the place where you previously were. I think the other useful thing that arbitration can do, and again, this is in the context of contracts where disputes often arise because of state inaction, say over, not giving necessary permits, or actions that the state shouldn't be taking, say a threat to remove a license. And sometimes those decisions are being made by, lower level functionaries who, may not have the big picture in hand. And actually, arbitration, given its kind of formal nature, and if you're bringing a claim against the state, it's often a good way of escalating those issues up to the more important decision makers who, will perhaps have a better idea of, the political importance of these points, and can actually make a good decision, a decision that is needed, and move things forward. Because the other thing that you find often is actually people in governments don't want to make a decision. They are, they don't feel empowered. They feel that they will be criticized if they make a decision and it ends up being wrong. And so sometimes forcing the decision higher to people who have the authority, are willing to make the decisions, can be the thing you need to actually get your negotiation or your, license application over the line.
Right. So decision making is important, as you correctly said. John, in terms of security, what role do you think the instruments like parent company guarantees, letter of credit, and bonds play in actually strengthening an investor's position? It could be during arbitration or even before arbitration. John, you're on mute again.
Thank you, Vivek, keeping us honest. We call it the chicken and egg problem. It's
Right.
great to come in with all these risk mitigation instruments, be it PCGs or parent company guarantees or LCs or bonds, etc. But at the end of the day, it's better to try and fix the clauses before you get into the mud, and then try and look for a water clarifier, as we call it. So, and we've been fortunate to be on both sides of the table here. So when I was in industry, we often negotiated parent company or holding company guarantees. And when they are cross-border or international, they usually have to be supported in some way by an LC, and usually an irrevocable LC, letter of credit. They can provide some overriding collateral that mitigates the risk. I wouldn't say always reduce, but mitigates the risk, at least the perceived risk. Of course, there is always the risk that remains of execution. And I think we'll talk about it in the next point, but the ConocoPhillips Venezuela case, where we were involved in the tribunal, the tribunal gave a pretty strong decision that is, ConocoPhillips is still trying to realize some of the gains from that very positive decision, and despite whatever guarantees there were in bonds and LCs. They are not a cover-all. It's not a great big duvet in a Canadian winter. No, it's not at all. And they will not always cover, for example, execution risks, as we've just discussed, or indeed country or exchange rate risks. If you do issue, just some of the experiences, if you do issue a guarantee, it usually has to be in an internationally traded currency. So it needs to be in one of the major currencies. Well, that might or might not cover all of the potential risk that is incurred in that project, particularly with the exchange rate risks that move around. If it's a bond, you might have an interest rate risk that shifts. And as you know, bond markets are somewhat sensitive. So at the end of the day, we tend to look more at irrevocable LCs, which international banks, the likes of HSBC, amongst others, would issue. But I think without putting the cart before the horse, we really look to see that the clauses themselves are as clear and as unambiguous as possible, so that there is less of a reliance on that kind of collateral. And where that collateral is required, then we make it an international instrument.
Right. So they are helpful, but not bulletproof. That's what we can say.
Indeed.
Right. So let's move from theory to practice. What actually happened when the clause hit the fan? Lucy, starting from you, could you walk us through a landmark energy arbitration that highlights how poor drafting or misaligned expectations caused loss to the parties or to the project?
My answer to this is it's what I think is the true one, but it's a slight cheat to your question. I think both parties lose out when a dispute goes to full arbitration proceedings. I don't think by the time you've got to arbitration, no one's really going to come out a winner. Apart from the major disruption to the business, people always underestimate what it's going to be like having your project manager taken away by the lawyers for weeks at a time to do witness statements. And then again, when the experts are doing their reports, you always need really substantial factual input from the lay client. And the drain on the business is really material. That's always understated. But even if you get through all that and you win the arbitration, you will very rarely get 100% of your claim, and you will never get all of your legal costs back. So on day one, you know, even if you've got a great case, that you're going to spend a lot of money that you probably won't see 30 or so % of it ever again, even if you're the winner, and you probably won't get 100% of your claim. So to me, that's the discount that you're starting with for what you'll do a deal at. International parties tend to be quite reluctant to do deals. It's quite hard to understand why, because often the parties to these disputes are extremely savvy commercial operators who obviously run mega businesses. But there's internationally, I think, and actually sort of maybe particularly in energy cases, there's a bit of a blind spot about the merits of doing a deal, and sometimes people seem to be worried about who will blink first, like making an offer is seen as weak in some way. And that I always try to like help my clients move past, because the winner is the person that gets out of the arbitration with a sensible deal attached to it, doesn't have to litigate anymore. We've discussed already that poor drafting obviously can lead to disputes, but that in reality poor drafting can be a feature, not a bug, of the original deal. I haven't done any cases that went to final hearing where it was just a pure dispute about what the contract meant. There's always absolutely myriads of factual and technical disputes as well. So poor drafting doesn't help, and it obviously feeds into increased risk on either side. But I'm not sure it's ever the pure cause. And I think the other thing that parties need to really remember is that arbitral tribunals are very, very merits focused. And sometimes one party is very reliant on a black letter approach to the contract. But what that's going to mean is that they have some kind of windfall result, or it just doesn't align with who the tribunal thinks the good guy is. And it's absolutely true that in court litigation in the UK, it's very important to be the good guy, tell a story that enables you to be the good guy. But in arbitration, it's that times 10. You've just absolutely got to think about, how do I present my case in this arbitration to show my client as the deserving party, and not the baddie. and that really makes a difference. It's very fuzzy. It's not black letter law in any way, but it really makes a difference to outcome in my experience. And then my sort of final point would be, you've just got to make sure, if you're the lay client in these arbitrations, or if you're the advisor, that you're making sure that the client is discounting enough internally for risk on high risk stakes, where there's like a single issue point where a lot of money turns on that point. Are they giving enough internal credit for the fact that they might lose that point? Even if they're more likely than not to win it, that still means there's a significant risk of losing it. So I don't want to sound too wet, but usually parties think, well, we'll be very aggressive, and sometimes that's a bad strategy for the tribunal, but also it can mean that you're throwing good money after bad. And I think in the end, if lawyers are going to be sort of helpful rather than parasitic, you should be helping your client to see where they're in a good money after bad situation, and where a deal can be done to get them out of just, paying my mortgage, which I'm delighted about from a personal point of view, but it isn't really very good business, not good business sense.
So it's not exactly a win in the end if you have burned through cost, time, and goodwill.
Only a win, only
really,
win
it's
for the
not a win.
lawyers, Vivek. Only win for the lawyers, and that nobody wants to give the lawyers a win.
Right. John, let's talk about valuation in action. You might have worked on damage calculations in many energy disputes. Can you share some example where arbitration either protected or failed to protect investor value due to poor evidence, valuation models, or contractual ambiguity?
Vivek, unfortunately, there are a few, and I'm sure James and Lucy have witnessed them. Obviously, the main one is the $8 billion case between ConocoPhillips and the Bolivian Republic of Venezuela, where the tribunal, if I'm not mistaken, it lasted 5 years or so in total, something like that. And it came down in favor of the investors. We did quite a lot of work for the client in terms of some robust modeling. We have some deep-seated expertise amongst the team in this quantum modeling, and not necessarily AI based, by the way, but together with some realistic assumptions on what was realizable in the but-for scenario that could have been realized had it not been for the expropriation by the state. And it's not unique to this case. I mean, you look at Argentina and YPF, or you look at Perenco in Ecuador, there's a whole bunch. But what comes out is that there is a pattern of red lights, as it were, pattern of some challenges and how they have been met or how they have been missed. The first is, I think James correctly says, and Lucy has commented, is the realistic or unrealistic expectations of the demand. Often it's positioning, whether it's part of a legal tactic or not. But we've seen clients who vehemently disagree with counsel on the quantum expectations. We want this and we want that. And as experts and independent experts, if I may, we reserve the right to disagree where we feel that it is not supported by the facts, and facts with a capital F, because often they can be subjective. So for us, where we found in the case, for example, of Venezuela, the tribunal came down in favor and awarded a huge amount, which unfortunately has not been realized or enjoyed by the party who won the majority of the laudo, the judgment. The main one was that they looked at the discounted cash flows and said, well, what are your assumptions on the discount rate? And the discount rate is something that when I teach it at university, I usually begin by saying, what does it mean to you? And, we've got some really smart international students in the class from around the globe. And the answers can be a complete 360. The bottom line is that the discount rates are supposed to adjust that amount of money that's projected out there to something realistic today. And, it includes political risk, and it includes market risk and all sorts of other things. And it usually talks to the investors. So if it's a publicly listed company, you want to reflect the trends and the performance of the share price, where the share price and its operating cash flows are reduced back to a net present value at some sort of rate. And in the case of Venezuela, the tribunal came back and asked for revisions of the discount rate on a couple of occasions. And the question would be why? Well, as is common in the sort of northwestern corner of Latin America, you have social values that are determined by legislation. So you have the social value of time, you have the social value of the currency, la divisa, or you have a social interest rate that you can recover losses for a value, for the time value of money. And these supersede whatever the tribunals judge, particularly if it's an international tribunal, ICC or ICSID, and which is required to be enforced in that country involving one of its national SOEs, state-owned enterprises. And in this case, the discount rate was viewed to be different to what the tribunal had considered, taking into account what the legislation was. So the legislatively determined interest rate. And the other one was also the pre-award interest, where the Mora rate was also adjusted. So there were a number of adjustments where, particularly I think, as both Lucy and James have indicated, where the arbitrators are well versed and understand the business side of the claim, then, and we've had quite a few where the tribunals have actually engaged in, well, what about this for the following reasons? Yeah, I think that makes sense. Let's do that. But it's not always the parties that agree, even if it is a discussion in the tribunal with the arbitrators. So at the end of the day, there are a number of cases that have given us some learnings, have introduced us into different perspectives. And we're actually authoring a paper in the next month exactly on these cases and what the learnings are.
Right. So let's just wrap up with a quick lightning round. If you had to give just one piece of advice to stakeholders entering new concessions in 2025, what would it be? James, starting from you.
So I think my point really picks up on something that Jean-Marie said earlier. It's really, I think, the need to learn from past experiences and to try and balance those risks and those financial rewards appropriately between the parties. As we've all said, these are long-term contracts. You need to be able to have a working relationship with the other party over numerous years. So trying to get kind of as much as you can now is usually comes back to bite you in the long run, and just leads to disagreements and renegotiations later. So learn from experience, try and balance the risks appropriately.
Lucy.
I think that the advice has to be become a combination of a polymath and a prophet. to try and predict geopolitical developments over the next few years, and the economic and regulatory impacts of things like tariff policy globally, what wars will be going on where, what effect that will have on supply chains. I think we are in uncertain times for businesses. So I think if you're an energy stakeholder entering a new concession in 2025, then I think you need to have your wits about you, really.
Right. John.
Just quickly, I think we've all agreed on one set of words: tell a story, make the story realistic and as easy as possible to understand, even in these challenging times. At the end of the day, where it relates to your experts, where possible, I would plead with parties and counsel, appoint experts that have multidisciplinary experience. Some of the guys we come up against, some of the folks we come up against are fantastic experts, but it's almost like the professor at university who can recite chapter and verse of his theories, but doesn't know the name of his students. And it's that kind of reality check that I think really helps. And we try, and as James says, we try and learn from the previous cases and what they bring to the table, and apply it to the reality of a specific case that's in front of us.
Right. So that was all from my side in terms of questions. Before we wind up, we have some questions in the Q&A box. If we can take a few of those. Okay, so there's a question. When arbitration is anticipated, what documentation or economic evidence should project owners begin compiling from day one to maximize claim success? John, you would like to answer this?
I think to Lucy's earlier point, having access to the besides all the legal documentation, which I think James and Lucy can clarify, but it's really the operating documents, rather than statements under oath from the factual witnesses. We try and rely on real documentation rather than what somebody has sworn to say. And then secondly, we certainly want to talk to the people in the field who actually in the jobs, who are actually managing those processes that are now under dispute, because they know more than perhaps some of the other experts, and that does help us.
Right. There's another question. From any of your arbitration experiences, how does the choice of seat, governing law, and institution impact the enforceability and utility of the process in such agreements? Maybe Lucy or James can answer this.
There's a wide range of possible answers to that question, I think. Obviously, if you've got a New York Convention country, then you should be okay in terms of enforceability. Neutrality, I think, depends on the tribunal, I would say, primarily, rather than anything like choice of law or the institution, or the choice of seat. There are obviously some countries which, especially if you're arbitrating against a government, you need to be very careful to tick every single procedural box. For example, I'm sure James had this experience, if you're arbitrating in the Middle East, you have to be very, very careful to swear your witnesses in correctly, for example, because that can be a ground for resisting enforcement. Sometimes the difficulties on enforcement are nothing to do with the technical legal position. They're to do with whether the government in question is going to comply.
Yeah.
Right.
I would say of those three, in terms of kind of enforceability and neutrality, the choice of seat is probably the most important. You can end up with some quite funky old arbitration laws still knocking around the place if you're not careful, which in my experience tribunals do not like, and tribunals get a little bit sensitive about, which can, you know, lead to issues, and again just extends the timetable because you're all talking about this kind of what should be an irrelevant point. And then of course you've got to deal with local courts and whether they can be a little bit interventionist. So if there's any of the three that you're able to negotiate on, try and go for choice of seat.
Right. Thanks, James. And with that, we close today's masterclass. Huge thanks to our brilliant panelists, Lucy, James, and John, for your candid, thoughtful, and at times beautifully blended insights. Thank you to Lexology and Mason for hosting this important conversation. And thank you all for tuning in. It was a great session. And thank you so much. Thanks so much.
Thanks, guys.
Thank you.
Thanks
Thank
so
you
much.
all. Take care now. Bye-bye.
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 That wraps up our masterclass. Thank you all for joining us today. A special thanks to our speakers, Jean-Marie, James, Lucy, and moderator Vivek for their time and efforts in preparing and delivering this session. As mentioned earlier, the session was recorded and we'll be sharing a copy of the recording with you in the coming days. Thank you once again and enjoy the rest of your day.
Thank you.